The following audio recording has been designed for learning purposes only. Do not share, distribute, or provide any type of copies, or this audio lesson will not be made available to you. Good luck with today's lesson.
The exam and all that. So what we will do, if there is anybody who wasn't here last class, though, I do have, oops, that's not supposed to be in there, the handouts. A couple of you guys walked out and I forgot to hand you your stuff. After you walked out, I'm like, darn it, I forgot to hand these. They were sitting right there. So that's there. What we're going to do is I will say don't toss everything away. I mean, you guys know how it is. I'm not going to retest on the material. If it's mentioned in the next set of material, you're responsible for it. But right now, you shouldn't be. I think pretty much we start moving into like the other areas where those aren't as common in the thing on what we're discussing. What we will do is we will get to the next part. And what we're going to focus on here is we're going to deal with our agency relationships. We're going to look at, eventually we'll get into employment. We'll get into things like the discrimination, all those aspects. We'll look at different laws that apply, you know, like ADA, FMLA, OSHA, those type of things, Occupational Health Safety Act. We'll talk about those. Those will be like 38 and 39, get into all that. The two chapters we're going to cover today deal with agency and the different types of relationships you will have with agencies. So there's this area of law that we know that is known as an agency. But what is an agency? When you guys hear that, what do you think of?
Like a department of some sort. Agency,
That's fine. I'm just, like, when you think of it, when I say there's an agency relationship, what do you think? Is that different to you than when you hear it's an agency, an agent?
Yeah, I guess a bunch of agents, that was what I was looking for.
Well, isn't an agency relationship when someone acts on behalf of another in terms of like signing stuff, representing them?
Mm-hmm. And the agent, well, so when we're talking about this, I'm looking for something as I talk to you guys too. When we look at this, the agency relationship, don't know what I did with your attendance sheet. The agency relationship is you will have one party who's acting on behalf of another party who's entering into a contract with a third party. So a lot of times what I'll say is sometimes it might get easier if you guys actually draw a map, kind of like when you did, if you ever drew the map in third party contracts, when you'd have the assigner assigning the contract to somebody on the thing there. So when we get into it, you kind of want to think of, here's one party. Okay. You kind of have this relationship here, right, between a principal and an agent. Because this person enters into a thing with this, it tells the agent, yes, you can go and act on my behalf. The agent then goes and acts here with the third party, but he's acting on behalf of the principal. And then really the contract's between who? The third party and the principal. And that's what we'll look at. So the agent is kind of acting on behalf of that person there. What'll happen here is the rights and liabilities are created to one individually by the acts of the other party on what they do. And this is where, because of what they did, this will now bind this person. When we get to the next chapter, we'll talk about what happens when this party is disclosed, undisclosed, partially disclosed. Then can this party ever be liable? But right now, let's just focus on this whole thing that this party is going to, this agent is going to work on behalf of the principal with this third party and create that contract between the there. Now, when we're working with situations involving agents, principals, we also have to, besides diagramming, we'll come into certain rights, liabilities. Those are going to be very similar, like when we talked about third-party contracts. The other area we're going to have to look at is you're going to have to realize there's a distinction between other different parties that could come into play here, because sometimes you could be an agent, you could be an employee. of the company. Sometimes you can be an employee or you might be an independent contractor. So we have to look at what are all these types of terms and what are we dealing with here. So let's talk about the little distinctions, because we're going to have things as master servant is one type of grouping you might see. The employer employee, we'll have that. We have our agency relationship that we've kind of done, the principal agent that I mentioned. And then we'll get into our independent contractors and who are independent contractors. So let's kind of look at these different, and that K is for contract. I just kind of abbreviated there. So let's look at the master servant. What are we talking about when you guys think master servant? Yes, we're going to think historically what? The master and the servant, right? Somebody would own the plantation or something. They'd have their servant working on their plantation for you. But historically, that's what we're talking about there. It was a servant who was employed to render services, okay, of any type and is under the control of that master. What you will start to realize, though, is we've kind of modernized it a little bit here, because the master had the right to control at all times. The servant did not have any independent discretion, right? This was our historically what we used to call it. Now it's very synonymous, as we don't call you master servant anymore, because now when you're working with someone, for someone at the company or wherever you're working, whether you're babysitting their kids or whatever it is, we're going to call you what? The employer employee, kind of there. So this is very similar to the master servant relationship. They are not, though, always hired maybe to represent the employer. So what'll happen sometimes is we'll learn that you can also be not only an employee, you might also be an agent. You could just be the agent for that employer. You know, not both. You might even be the independent contractor for the employer. We'll talk about those type of roles. Principal agent. That's where we have the agent who's acting on behalf of a principal with a third person. While the servant employee type relationship, you're actually working either for the master employer. Where here, you're working for the party you work for. This one, you're working on behalf of a principal, we'll call you. So that's how it's different there. Okay. What happens when we talk about the servant is the agency is going to be distinguished from the servant employee, and that the agent actually has representative character and derivative authority, because they're going to have different authorities on how they can act sometimes. They're going to have a characterness to them, okay? It gives that agent a sense of discretion in carrying out the purpose of the principal, versus here, we're just going to do with what? What they tell us to do, kind of. We're following their directions. Here, you're going to have a little bit of authority when you are working it out on how you handle some of that situation there, okay? Now, like again, we'll get into when you can be both, and we'll look at situations there. One of the examples I will tell you is a store manager. They might act as agents for purposes when they are doing things like personnel, purchasing goods, but they'll act maybe like the employee when they're doing the keeping of records. Do you see where we're going? And that's why we say sometimes you can have a dual role. Sometimes you could be both an employee and an agent, and we'll come back to those examples, because maybe you are hired to, like at KFC, and you're selling all their stuff and that, but then you also might be an agent because maybe you're going around to other locations, what? Doing the distribution of the chicken, and do you see where we're going? So on that, you might be acting more like an agent versus the employee of the company when you're working in there. Independent contractors. They're going to be different because they're going to render services in the course of an independent occupation, and they're not under the control of the employer or the servant. And a lot of times, I'll just go back to the employer-employee here, but they're not working. They're independent, which means the employer doesn't tell you what time you start working, how you should be working it, what tools to use. You're not using their tools, all that stuff. You're an independent contractor. They're kind of not dictating. If all of a sudden it looks like they're actually telling you what to do, when you should work, how you should work, they're giving you all the supplies and everything, and then all of a sudden someone gets injured and they try to say, well, they're not an employee, they're an independent contractor. When the court starts looking at that and they start going, well, wait a minute, you're telling them they have to work from such and such time. You're telling them how to do the job. They're using all your stuff. They're not really an independent contractor. They're more your what? An employee. And therefore, we're not going to relieve you of liability to that other party's injuries because you're trying to say they're an independent. No, you're going to be liable because they were your employee. So you do get into that type of thing there. So you're actually here hired to do a project, and you're usually not under the control of the employer. Any questions so far? You can also be both an employee and an independent contractor. So an example here, going back to that Colonel Sanders. Maybe you're the distributor of the Sanders goods, but you also help maybe Chicken Little unload the supplies, all the shipments that arrive. Okay? So what could happen is, as Chicken Little's doing that, when they're the distributing and unloading and all those things, they could be the independent contractor, but they could be a servant, or they're independent contractor when they're doing the distributing, but they could be that employee when they are unloading. Do you see where we're going? So it kind of gets into that type of thing. And you do have to understand the features and to understand the distinguishing features between each, because as you do this, between that agent, the servant, the independent contractor, all those things, the rule is that the doctrine of respondeat superior will apply to employees, servants, I should say, and agents, but it doesn't apply to independent contractors. And when we say respondeat superior, we'll come back to that, because what it says is we're going to impute liability to our employer for the employee's acts. As long as you're doing it within the scope of employment, you're going to be liable for what they did, type thing. But if they're an independent, you're not going to be liable, because they're what? Not your employee. And then we'll talk about the exceptions to that, because there are a few exceptions where we could hold the employer liable for torts, injuries that were caused by independent contractors, but it isn't under our respondeat superior theory. It'll be an exception to the rules there. So let's talk about Sly Fox for a minute. We have Sly Fox, and Sly Fox is an attorney, okay? And what Sly Fox does is Mother Hen happens to be injured in an accident, and it's a skiing accident at the Snow Mountain Resort. So what does she do? She goes and she hires Sly Fox to represent her. Now, Mother Hen authorizes Sly Fox to go and settle the case for a minimum of $100,000. So she's injured in the incident at the skiing resort. She hires Sly Fox. She gives him authority to settle for a minimum of $100,000. And in lieu of such a settlement, to file suit against Snow Mountain. Is the attorney Sly Fox then an employee of the client or an agent? Sly Fox. We got Mother Hen. She's injured in this thing. She goes and she hires Sly Fox to represent her. And the question becomes, is he an agent or an independent contractor? Which one do you guys think? Why?
Because he's strictly in a representative capacity.
Anybody disagree? Or does everybody say agent? And it is an agent here, because here what happens here is he's the agent. He's not subject to the client's rights, controls, and all that. She gave him the authority to say you can settle for a minimum of here. He can't just outright settle for anything. He always has to go back and ask the client. The client has the final say. We're just acting on behalf of that client. You know, we're acting as that agent for the principal. What do you want from this party? You know, and then we'll come back to you and say, is this what you agree to or not? So you'll get into that. There are several different types of agents that we'll talk about. So some of the agents are special agents, general agents, and universal agents. We'll do this. Okay, those are the three types of agents that we could have. So let's talk about who is a special agent. If you're a special agent, you're going to do things that are specific acts or transactions. You are one who are performing that specific act. You're a special agent to do that specific act. If you're a general agent, it's going to be a little more broad because it's general. Okay? The general agent can transact all affairs in connection with the business. And a universal agent, you can do all acts that can be delegated. So when we're doing general, it's broad, but it's within the business. Do you get where we're going? Where universal is kind of a little more now going more universe, bigger than broad, okay, than the general agent there. So you do want to realize the distinctions before those. The agent can also have an interest in the authority or in the subject matter. So this is where we will get into if the agent has an interest in the authority, you kind of get into them being coupled with an interest, an agent coupled with an interest in authority, or they might not have that authority. coupled with the interest there, that they don't have that interest in the subject matter. Okay, they might also have been given the interest in the subject matter when they are selling something. So you kind of sometimes have to figure out, do they have an interest in the authority? Do they have an interest in the subject matter? And that, is there an agency that was coupled with that interest? How do we create the agency? So, okay, we know who the and by the way, who is the principal? We know the agent is working on behalf of the principal. Who is the principal? Can it be anybody?
A person or a firm.
Yeah, but it's anybody who has that competency, right? Who can enter into contracts? Because don't forget here, it's anyone who's, the principal can be anyone who is competent to act or may act through an agent, and they have to have contractual capacity, which means, can an agent work on behalf of a minor? Yes. However, what is the contract then with this principal if the principal's a minor with this third party? Valid, void, or voidable? Do you see where we're going? Because if they're a minor, they might lack capacity. Therefore, that contract could still be a voidable contract, which means the minor may get out of it. Okay? So if, as long as it's here, somebody who's an adult who's presumed to have capacity and all that stuff, it's going to be a valid binding contract. Can an agent ever be a minor acting on behalf of someone? Who is the contract between? So, could I tell my son and say, hey, Joseph, I don't want my car anymore. Go ahead and try and sell my Traverse. Well, he's probably not the kid I should use because he's an adult. Let's use my other one who's a minor, Adam. If I tell Adam, go ahead, you can sell my car. Can he sell my car, say, to John Smith over there? If John wants to buy my car? Yeah. Did I give him authority to sell my car? Yes. Who's the contract between? Me and John Smith. So even though he's a minor, that's not really going to affect this because I have what? Capacity to enter into it. It's still going to be a valid contract even though he was a minor.
Would you be liable for negligence if anything happened and you were the one who hired a minor as an agent?
When you say for negligence, in what aspect?
Or just like, whether it was, damages or, just making a stupid decision, like, would you be liable to anything because you hired a minor as an agent?
Well, it's whoever I want to give authority to act on my behalf, because don't forget, this gets into us as he may be liable to me for something.
Okay.
Do you get where I'm going? Did the agent act with their due care, reasonable? We'll get into that, loyalty,
Okay.
all those type of things. But when you're saying like him entering into the third party, that contract's really, we're going to right now presume that they know
Okay.
that the contract's between what?
You and
Me and the third
Yeah.
party. Me and John Smith there. Because if John knows that, hey, Adam's working on my behalf to sell the car, it's really between us,
Yeah.
And we'll look at situations when this person can be liable, and I might go after this person. So how do we create then an agency? How do we create an agency? Well, we can create one by appointment. We can create it by conduct, ratification, or operation of law. And we'll talk about each of these. These are all the different ways we can create our agency relationships. So one thing you have to realize, if you're going to create an agency relationship, you should probably put the agency powers and duties in writing. Why would we want to do this? Do we always have to have this possibly in writing? Probably not. I probably could give one, but we probably do want it in writing. And why would I want to put what the agent's powers and authorities are in writing? Go ahead.
Maybe they can change, since you don't have it in writing, you can't really say what a person said you can.
Right, because it tells them what authority, so the third person might know that if I hire Adam and I tell him maybe I'm in the business of selling sheep, right? Or let me not say selling sheep. I'm buying sheep all the time. And I tell him he only has authority to buy sheep. And then all of a sudden he starts buying on me chickens and cows. That would say, no, you don't have authority maybe to do this or that. So if we put that in writing, it kind of lets others also know. And it also lets the agent know. Because now if he goes beyond his scope of authority, I could say what? You didn't have authority to do that. I never gave you authority to do what you did. So it is a good thing to put it in there. If the agency agreement is complete, then you might not have as many questions as to whether the agent was or was not authorized to act, because you've put it in writing to tell them what they're allowed to do, what they're not allowed to do. If for some reason there is any questions, we can go right back to that writing then. And that's where it gets down to when you said it'll let you know what you can or cannot do. The other thing, and by the way, the third party can also always check with the principal too if they're unsure. Like if all of a sudden they know they're working with an agent and they're really not sure, like, well, do you have authority to do this? You can always ask the principal too. Do they really have authority? Or they can ask, do you have authority to do this? There. Because the agent can be exposed somewhat to liability for unauthorized acts, the written agreement will clearly delineate their liability for these things. Okay? We know what'll happen here is it will delineate for them the agent's authority. And that's going to be the most important thing, because we know at times they could be liable for something. And this is going to help them too, maybe, so they don't get exposed to that liability to say, oh, wait, I'm not allowed to do this, by looking at that. So I'll be okay if I don't do this because I know I'm okay. The principal's liability is not limited by the agreement itself, but it can often prevent that agent from exceeding their authority. So let's discuss the authority further after we discuss the formation of the agency relationships, because then we'll talk about what type of authority can that agent actually have and how did they get it. So let's talk about creating our agency by appointment. This can be either orally or in writing. I could literally just say to Emma, I want you to be my agent. Right? We might not have it in writing. I've orally appointed her to go ahead and be my agent. And I might tell her, go ahead, you can sell my car. I've given her that authority, right? I've orally asked her to be my agent and stuff like that. Or maybe I put it in writing and sent it to her and said, hey, I want you to be my agent there. If you have written authorization, that authorization is going to be known as a power of attorney. Okay? The agent acting under that power of attorney is also going to be known as an attorney in fact. A written authorization, if we wanted to do an example, a lot of it, maybe I send, bless you, I send Emma a letter telling her I give her authority to go ahead and sell land that I own. And by the way, land contracts usually have to be in writing, so it'd be a good thing to have your agency in writing, because usually you're going to want that because it's involving land. That way they know they have the authority to go and sell that land on you. Another type of agency we said we can create is going to be by conduct. So when we're talking about here, this is where the principal may give a third party the belief that the agent has authority to act. And don't ask me why, but right now I have Trump in my mind, because he's always going, go ask Rudy. Do you get where I'm going? Go ask Rudy. Rudy knows what to do. What is that implying then?
He has an agent.
That if Rudy's acting as his agent, he's given Rudy authority to do what?
Act on his behalf.
On his behalf. And that's why I just said that popped in my mind. Or I could say something where I could go, hey Brad, I want to order a bunch of meat from you, from your business and stuff, but I'll go talk to Emma because Emma can handle it for me. By me telling him that, even though I never told Emma that she had that, Brad now goes and talks to Emma and said, hey, Jennifer told me to come see you to order the meat. By me telling him to go see her by my conduct, I'm implying almost that she has what?
Agency.
The agency, the authority to go and act on my behalf. By my conduct on what I've done, I've given him the impression that, hey, Emma has authority to go and act on my behalf. So you get into that. Realize that the apparent authority here, because this is known, by the way, as apparent authority. What you have to realize, though, and this is important, apparent authority is what I make the third party believe, not what Emma makes him believe. It's what I make him believe. That under my belief, he believes that she has what? The authority to act on my behalf. And that is important on apparent authority, and we'll get into the different types of authority. But that's one of it. It's what the third party believes based on the principal's actions. Okay. And by the way, they'll use an objective test here, not a subjective. What would the reasonable person? Because if anybody heard that, like I said, when I used the Trump with the Rudy, go ask Rudy. If anybody heard that, you would think, how many of you would say, yeah, Rudy has authority to act on his behalf? Or if anybody heard me say to him, Brad, go talk to Emma about purchasing meat. You guys would all assume that Emma has what? Authority based on my behalf. Any questions so far on that one? All right, let's talk about ratification. Oh, I accidentally wrote conduct twice. You guys didn't catch that on me. This should have said ratification. Okay. And I'm kind of out of order, but let's go to this one, the ratification. Your conduct by agency created by ratification. Here, the agent may have acted on the principal's behalf, but he really acted on the behalf without authority. If this occurs, what happens then? The principal can actually ratify the agent's authority, or we can ignore them. So this might depend on how we want to go about doing it. So when we are doing things here, let me do the following example. Let's say Caleb goes and he purchases some new computers, desks. Do you see where we're going? And he says he's purchasing it on my behalf. But I never gave him authority to purchase what? The office equipment, furniture, and all that. And then he puts it in the building that I lease. And I go and I sit in the building, I start using the furniture, I start using the equipment. Do you see where we're going? And now 6 months goes by, and then they send me the bill for it, and I say, I'm not paying for that. He didn't have authority to what? Buy it. By my actions, have I ratified his unauthorized authority? Because he didn't have authority to purchase it. I never gave him that authority. But even though he went above his authority and did it, by me using that equipment, I've ratified then, the agency. Yeah, that authority. I kind of ratified it to do that. There. When we are doing the first steps, this occurs, okay? The first step is to see whether the conditions for ratification were satisfied. So what are the conditions then? It's the agent must have been purported to act on behalf of or as an agent for the identified principal. The principal is capable at that time of authorizing the act. There was nothing wrong with me. When he actually went and purchased all that stuff, right? He's acting as if he's acting on my behalf. I know, and by the way, I also know he's done this. I'm well informed of what he's done. And I still go and use what? The stuff. Because the other one is the principal must ratify the act before the third person withdraws. For ratification, the acts must generally be legal. There's nothing wrong with him renting equipment. It's not like he was, purchasing. I just saw in California where they had that big drug thing with, what was that, 340-something pounds of marijuana. It was an illegal building. There was 145 marijuana plants or something like that growing at something like 300 or 400 pounds of marijuana. But it was illegal. It's not like he's doing anything like that, purchasing it illegally or something there. And I had full knowledge of all the material facts. After you establish all these conditions are satisfied and stuff, the next step is to see whether the principal ratified it, which can be shown by my words or conduct. Here it was my conduct because how many months went by and I was sitting there actually using the furniture, using the equipment and all that. That's going to be deemed ratification. Okay. The party who will benefit from has the burden of proving the agency relationship. They're going to have to show that. And then the last way that we can actually create an agency is by operation of law. This is where the law kind of imposes one there too. So let's talk about what type of authority can we give. Because what we've done is we've talked about the agency relationships and how you go about and how we've created these. But let's now talk about, okay, we've created it. But what authority are you giving your agent when we create these? What type of authority can they have? And if you are somebody who's benefiting from this agency, you're going to have the burden to show that this agency relationship exists. So then you can enforce that contract. Because let's just say Brad sold the car to Emma. We're going to make you the agent at the moment, right? And she's now trying to enforce. Who's ever benefiting from it, they have that burden of showing that what? This agency relationship exists. somehow in the thing there. So let's talk about the different types of authorities. And we have express authority, apparent authority, we have inherent authority, incidental authority, we have customary authority, and then I also have actual authority. So you can even kind of get along the lines of express. Actual authority is granted either expressly or implied to the agent from the principal. So, I mean, if you have actual authority and it was expressly implied, you're going to have express authority there. Because express authority was granted by words, which expressly and directly authorize the agent to engage in certain conduct on behalf of the principal. It can be oral, it can be in writing, whether it's express or not. When we have inherent authority, it's going to be inherent of the agent that arises solely from the existence of the agency relationship. It's inherent that you have that authority because it arose from that relationship. Let me come down to these and we'll get back to the apparent. Incidental authority, that's implied authority. So it's implied kind of by law. It's your acts were reasonably necessary to carry out express authority. So in order for you to carry out this one, we'll give you this one because it's implied that you are allowed to do it. And customary authority is another type of implied authority. That's authority implied from the surrounding facts and circumstances to do an act according to the community's custom. And then the last one up there was the apparent authority. This is authority that I said the third party reasonably believes that the agent possesses and relies on due to the words or actions of the principal. Okay. This is also, just so you know, you might see it called ostensibly authority, like that's another name for it. I'll put it that way. Hold on. Oh, wait, I didn't spell it right. There we go. Ostensible. All right. I feel like I spelled it right. There. If you are a third party and you are dealing then with a person who claims to be an agent, you cannot rely on the agent's statement concerning the fact of agency or the extent of the authority. As the third party, if you have any doubt, you should verify the agency relationship. So if you're really unsure of and you're not sure like that Caleb has authority maybe to purchase the goods on my behalf, all the crop or something, and you have any doubt on that, you're going to want to verify. Do they really have authority to act as an agent there? Okay? And to do that, you could also verify that authority with me, the principal. Whether it's calling me up, emailing me, whatever it is, to say, hey, does Caleb really have the authority to do this, to purchase on your behalf? Also, the third party, as a third party, you should notice any acts by the agent that may be adverse to the principal's interest. Okay? But again, the principal, you can go and ask the principal about that authority. Because all of a sudden, let's say Caleb's doing things on my behalf, and he's purchasing cars for me, and he purchases the cars for me, but then maybe he's doing something against my interest where he starts purchasing the cars for himself. If you see where we're going or things like that, you can go and ask. Or additional things. And we'll look at different fact patterns. If you are a third party and you're aware of any limitation on the agent's authority, you cannot ignore that limitation. So I can't pretend that I'm not aware of something. So if Brad was working with Caleb and Caleb was working on my behalf and Brad knows that he cannot do certain things, you can't just ignore it and say, oh, okay, well, I'll still let you purchase it on her behalf, even though I know you're not supposed to what? Do it. Any questions so far? Okay. There could be obvious limitations. There could be secret limitations. If the limitation is obvious, like I said, then the third party should realize it, that the contract entered into with the agent is not going to be a valid contract unless the principal does what, guys? Because if you know he doesn't have authority to do it, you're going to have to do what up here? Ratify it. Because it's obvious. He knows he doesn't have authority. He's gone above his authority. So he's got to hope that I'm going to what? Ratify whatever he did. All right. Okay. The other thing. Let's see. You may believe the principal should be relieved under the contract because the agent was forbidden from engaging in that certain activity. However, the principal could be bound because the court will find him bound. They'll find him at fault then in hiring. Who did you hire as the agent? And that's why, Caleb, remember when I asked you when I said negligent in what way?
Yeah.
If they found that I was negligent in who I hired as my agent, they might make me bound to say, well, you should have taken more care in who you hired to use as your agent.
Yeah, and they would have to ratify.
Yeah.
Or show the burden of proof
Yeah.
based on what negligence was.
And that's what it kind of went to when I asked you in what way I really can't, because there were different ways that I was like, when you get to things later, like, because remember I said we're going to talk about employees and all this, agents, what happens if they injured somebody, a third party, while in the scope
Yeah.
of employment? Do you see where we're going? That's why when you had said negligent, and I was asking you in which way are we looking. But yeah, we could maybe be liable because the court might say, hey, you were negligent in who you hired. You
Yeah.
should have taken more care.
Especially with the example that you gave and using your kid to buy your cars. I'm like, you know, who would really hire their kid as an agent to buy motor vehicles for them on their behalf?
Well, I was going to say, unless my kid was probably some of them. Now me, I don't get into cars as much. If they get into cars, they'd probably tell me, that's a cool car. Yeah, you really need this one. And I might trust their opinion more. You know what I mean? But you're right, depending on what I'm looking for, could play a factor there. Once the agency is terminated, actually, let me back up before we get to termination. Agents, as an agent, you owe certain duties to the principal. So what duties do you owe? You have a duty of care, to be loyal. Okay, you have to be faithful to them. This duty of loyalty or faithful to the principal, which means you should not obtain any secret benefit from the agency. Okay, and that's what we were talking about, like maybe you shouldn't do things to further your interests without informing them because you have this duty of loyalty to me. Also, you should aid or disclose you should not aid or disclose any information to my competitors if you're working on my behalf. The agent should follow all lawful instructions by acting obedient and performing in the manner that's specified. Now, what will happen here is also the agent has to act with reasonable care, and you must account to the principal for all of the principal's property or money that came into your possession. So if you're collecting on my behalf payments, you technically then are accepting it. So if, let's say Emma paid Caleb, right, on my behalf, but was giving him all the money and he's collecting it all, he's going to have this duty to account for it all. And then yet, when she pays him, that's deemed as if she's paid who?
You.
Me. So if all of a sudden Caleb started like milking some of that money, do you see where we're going? She's really paid to me. I might have to go after who? Caleb. It's, hey, you paid my agent. You had authority to go ahead and pay him. I didn't tell you otherwise. And we're going to count it there. And he has a duty to account for me, all that there. Also, what will happen here is the agent must inform the principal of all relevant facts pertaining to the agency. Once, though, we terminate the agency, the agent's duties continue only to wind up matters. So if he's still finishing stuff up, we'll let him wind up matters. He just can't now go above and beyond what? You can't create something new. You can wind up maybe what you were finishing up, but you can't now enter into contracts on my behalf and new things there. So let's look at a couple examples here. I have Marie Antoinette. And Marie Antoinette owns a cannery and she employs Louis XVI as her agent to buy produce for canning. So you have Marie and you have Louis. Okay, so Louis the 16th. And what she does is she owns this canning and she employs him as an agent to buy produce. Okay. All right. So what happens here? Louis is given instructions with some degree of latitude on the type of vegetables that he is going to purchase for her, right? Because she does canning and all this stuff. And what does he do for the season? Louis does not have authority to purchase anything else. He now goes and he negotiates the purchase of beans for Marie from Anne Boleyn. So he goes and he purchases beans from Anne. And Anne is a local grower. This purchase equals the maximum number of beans that Marie desires. Because the price of the beans is so reasonable, and Louis XVI has purchased all the beans he needs for Marie, he decides he's going to purchase 200 bushels for himself. Do you guys see where we're going? Is that a breach of his fiduciary duty? So he has this authority to go and purchase all of the produce that's allowed and nothing more. He goes, he purchases all the beans that she will need, and because it's such a reasonable price, he decides he's going to also purchase 200 bushels for himself. Has he breached his fiduciary duty, and why?
But they were supposed to buy many beans.
And what should he probably have done?
Called her up or something and like, hey, this is a good deal on beans.
Or made the soup and ate the soup real quick.
But he still would have breached his duty, wouldn't he?
Yeah, I know, I'm
But-
kidding.
But do you see where we're going? Let's keep adding now to the facts for a minute. So now, after purchasing the beans, he notices that Anne has an excellent price on high quality peas. And he purchases 1,000 bushels for himself.
He really wants to make soup.
Or let's say he purchases 100 bushels of peaches for himself. Do you guys with me so far? So now we get peas, peaches. I'm going to throw more things in here. He purchased for himself. He also notices that Anne has a truck for sale, and it's used in handling the hauling of produce, and he goes and he purchases that for himself. So a truck that's used for hauling produce, he also goes and purchases. Okay? Does it make a difference if the principal used the same type of truck at the cannery? If Marie happened to use that same truck that he just went and purchased for himself? So you don't think it makes a difference? Do you think he still owes her a fiduciary duty or not?
Yeah, I feel like he still has to owe her money because she didn't say, hey, go buy another truck.
Mm-hmm. We're still with Marie because she has the cannery. We're still with her. He knows. What if her truck had recently been destroyed, one of her trucks, by a fire?
But still, she didn't tell him to go buy another truck.
He didn't. He purchased all these for himself. Is he breaching their fiduciary duty? Do you see where we're going?
Mm-hmm.
And that's why I'm just asking questions like, does it make a difference if he goes and purchases a truck? We know the authority tells him do we think the peas and the peaches right off the bat are wrong? It's when we start getting into the truck, he doesn't have authority to purchase anything but what? The produce, right? But then the question becomes, well, what if he knows one of her trucks recently was destroyed in a fire? And this person Anne happens to be selling a truck that she could what?
That she could
Use,
actually
but he
buy.
goes and purchases it himself. Let me throw one more thing in there. What if Anne happens to have a Corvette she's selling? And he goes and he purchases the Corvette for himself. Does that make a difference if Marie happens to collect Corvettes? And she once told him, boy, if you ever see that model Corvette for sale, be sure to let me know because I need it for my collection.
Wouldn't that be different though? Because she said if you see that model, then. But he still didn't let her know that he was buying that car.
So what do you say? So you think, are we all in agreement that this is a yes, the food?
That he's breaching his duty by buying the food? Or
Well,
that
the
he's
question
not?
is, this is where you have to determine, is it questionable or not? Like, could he be in breach? Is he in breach, do you think?
I think the truck is the most breach of duty out of all the videos.
You think the truck?
Yeah, I think the truck is where things start to get a little fishy.
I think all of it is fishy because she only told them to buy the produce, like a certain produce. But there was nothing wrong with the beans, though.
Is he giving her money? Like, if he's...
No, he's purchasing these for himself. So he has authority to purchase her things. He
Yeah,
purchases her beans for her.
Yeah.
Then he realizes, ooh, they got some peas that are just as good. Let me purchase the peas for myself, even though I know I can purchase what for her? Peas, because I have authority to purchase peas. But I'm going to take it myself. Then we have the truck he's going to purchase himself, even though maybe he knows that her truck was destroyed in a fire.
So,
And the question is he doing something adverse to the agency's interest?
well, my question is like, if he's using the agent's money, is he paying her back?
He's not using the agent's money to purchase his stuff.
Oh, he's
Okay.
using his own money?
Right. The question, though, is he allowed to do it as an agent?
If I was the principal, as long as I got my money back, I wouldn't care about the peas and the peaches and the beans or whatever. But if he knew that I had a truck collection and just bought a truck that I was interested in buying.
Well, that's the Corvette. She has a Corvette collection.
Oh, the Corvette collection.
Yeah. Let me see this. I'll write Corvette down here. The truck was, he knows hers was destroyed in a fire, and that Ann happens to be selling a truck.
If I see him on the road with that Corvette, if I was a principal, I would not be happy.
So you say the Corvette is it for you?
When you say yourself, you're saying he's buying it for him?
He's buying it for himself. For him.
Oh, I don't think all that's wrong.
Why do you think it's all wrong?
Because he's buying it for himself, not buying it for her. He's an agent for her, so.
Correct, he is an
All
agent.
personal gain, I don't see, I think that's wrong.
You gotta look like you're still hee-hawing here. Which way are you going?
I'm trying to think because she gave him permission to buy the produce, so the peaches and the peas does not count as the produce, right?
Yeah, you could probably
But
throw that.
In the contract, did she say?
Nope, he only has authority for her. The only authority she gives him to buy on her behalf is the produce, the vegetables and stuff, nothing
And
else.
none of it is on her behalf though, the peaches, the peas, the truck, but the
Correct.
Corvette.
She did once say to him,
Yeah, so I.
if
feel
you
like-
ever notice this make or model, let me know because I need it for my collection.
Okay, so I feel like the peaches, the peas, and the truck, that's all bad, but the Corvette is, that's good because it's on her behalf, because she physically said,
If you see the model, then buy it.
right, I agree.
You going that route? Does everybody agree? Here the answers were yes to the bushels, questionable to the truck, and no to the Corvette. You
To
know,
the Corvette?
That's what I kind
because
of
it's
thought.
kind of way out there.
Yeah.
Because he's only hired to do what?
The produce is inside
Hire
the
produce.
scope.
That's why it's yes to the other produce because it looks like you're what then? It goes back to what you said. Well, yeah, but he has authority for her to buy this on her behalf. He's an agent for her on this. And he's purchasing that for himself now. He's kind of, unless you inform her and she says it's what? Okay. Because really that's against her interest then because if she's getting it at a reasonable price and let's just say resells it and he purchases it at a reasonable site, is he going to resell it? Do you see where we're going on her? Is it against her interest? He's using her advantage for his advantage, something he would have never maybe known there. And that's why they say the truck could be a little questionable though because he also knows that it's a truck she would use in her business and hers was destroyed by a fire. The Corvette's kind of just totally what? Irrelevant to the
Yeah, but
canning.
She told him if he sees that model Corvette, then buy it.
She just said, be sure, if you ever see that model for sale, be sure to let me know because I need it for my collection.
Yeah, and he didn't.
He just
call and
said-
let her know. He just bought it.
But is that part of his authority? I mean, she just kind of said, hey, if you ever see this, let me know because I have a collection, but she never really made him an agent to purchase.
Oh, yeah, okay, I see, yeah.
Do you see where we're going?
Mhm.
Is everybody kind of there? Let's look at a couple others then. And these ones are a little bit long. So I'm going to hold my little thing. I'm not lying when I say they're long. I have Dr. Seuss. Okay. And Dr. Seuss is the corporate secretary for the Sam I Am Company. The company's office manager usually handles the arrangements for the annual meeting of shareholders and has express authority to make all necessary contracts. However, this year the office manager, Bartholomew, had an oblique virus and couldn't set up the meeting. So we all remember that Dr. Seuss is the secretary. Dr. Seuss, so couldn't set up the meeting, Dr. Seuss into that void. He looks through the yellow pages and he hires the Cat and the Hat caterers to provide 200 servings of green egg and ham. So what does he do? He hires Cat and Hat. I'm just going to do that. And we have what? The company, right? Okay. At the meeting, the directors, officers, and shareholders all eat the green eggs and ham. When Cat in the Hat sends its bill, Sam I Am refuses to pay, claiming that Dr. Seuss, his corporate secretary, had no power to bind the corporation. What result? You guys need me to repeat those? Okay. Dr. Seuss is the corporate secretary with the Sam I Am, bless you, company. The company's office manager usually handles the arrangements for the annual meeting of shareholders and has the express authority to make all the necessary contracts. However, this year, the office manager, Bartholomew, had an oblique virus and couldn't set up the meeting. So Dr. Seuss, what does they do? Fills that void. He looks through the yellow pages. He hires Cat in the Hat caterers to provide 200 servings of green eggs and ham. At the meeting, the directors, officers, and shareholders all eat the green eggs and ham. When Cat in the Hat sends its bill, Sam I Am refuses to pay, claiming that Dr. Seuss, his corporate secretary, had no power to bind the corporation. What result? Who wins? So if you identify who's acting as an agent. Okay. Who's the principal? Who's the third party? Okay. This way at least we identify, right?
Cat and Hat.
Why?
They ratified it, they ate it.
There you go. Even though you know what I mean, he's not normally there, they've ratified it because they ate it. They're liable on the grounds of ratification. The issue here is the corporate officer's ability to bind the corporation, and here's the general rule. As a general rule, corporate secretaries do not have any authority to bind a corporation. That's just the general rule there. Okay. However, this doesn't mean that a corporation can't be bound by a corporate secretary's act. One of the ways to ratify the act that's going to bind them would be here, the ratification, because what did the secretary do? Ordered green eggs and ham for this meeting because the person who normally doesn't couldn't do it. And what did you guys do at the meeting?
We ate it.
You ate it, and therefore you've ratified it. Okay? Ratification occurs when the corporation either expressly adopts the unauthorized act or accepts the benefits of the act, and hereby eating it, they've accepted it. And they've also benefited because they filled their tummies, if you want to do it that way. Let's just say that Dr. Seuss had ordered green eggs and hams from Cat in the Hat for last year's annual meeting, and the company had paid for it. And this year, when he orders it, they now refuse to pay. Does that make a difference? No, because there, they would have thought that he had what? Authority, because he ordered it the last year, you paid for it. So when he ordered it this year, we would have thought he had the same authority to do what? Like he did last year. Let's talk about Beetlejuice. Beetlejuice is treasurer, Okay. I'll try and diagram it for you guys. He's treasurer for the Lucky Stiff Funeral Home Inc. Okay. He's appalled by the junky office furniture he's had to put up with for 4 years, and he's tried in vain to get the directors to buy new stuff. Fed up, he sends a purchase order to the Dio Furniture Store. And he orders $10,000 worth of furniture on Lucky Stiff's behalf. Lucky Stiff has never bought anything from Dio before. Dio delivers the furniture to Lucky Stiff, and Beetlejuice signs for it. So what does he do? He orders the furniture, they deliver it, they send the bill, they're obviously seeking what from them? Payment, and they refuse. They immediately disavow any knowledge of the order. Is Beetlejuice here personally liable?
Wouldn't he be? Because they didn't know about the order.
And have they ever ordered from them before?
No.
Everybody in agreement?
Yeah.
Yeah. So here, yes, when the corporate officer purports to act in a corporation's on the corporation's behalf, he impliedly warrants his authority to bind it. If the authority doesn't in fact exist, the officer is going to be liable for that breach of warranty. And as a result, he's going to be then liable to Dio. Because he didn't have the authority, and they immediately said what? No, we're not taking this. And we've never ordered from you before. Do you know what I mean? So it's not like, now, could it have been different had he ordered from them in the past? Do you see how that goes? Because then they might say, well, you've ordered from the past, you've paid that bill. They may have had authority there. Any questions on those so far? And again, it's the fact that he never ordered from them before that's going to negate that apparent authority, right? The implied authority. Okay. Principal owes certain duties and liabilities to agent. So what happens is the principal must pay the agent for his services. So, okay, if I'm going to hire you, I do owe you something here for acting as my agent. Now here I know the secretary, but we could even go here if it was my son or whoever, right? I might owe them something for acting as my agent there. It could be for repeating transactions. It could be for post-agency transactions. It could be a part of agreed compensation. We will reimburse the agent for proper expenditures or possibly indemnify them, okay, for any loss. So if, let's say, I'm going to do the son who's older. Let's say I give him the authority to go and purchase a car for me, and he pays for the car. Do you get where I'm going? As my agent, I would then indemnify him by paying him what? The cost that he paid for the car, I would pay him back. Because otherwise he would suffer a loss because he would have paid for my car and then I would have owed him something. It's not like I get it for free there. So we get into that type of thing. The principal also has to allow the agent to perform during the time specified under the agency agreement. Now, how do we terminate our agency relationship? We can terminate it by an act. We can terminate it by operation of law. So when we get into this, what do we mean when we say the parties act? Here what we're talking about is the agency may terminate because there was an expiration listed in that agency agreement. Maybe I only give you authority to act as my agent for 2 years. Well, guess what? At the end of 2 years, you no longer have authority to what? Act on my behalf. It's terminated upon that time there. So we'll get into that. The other thing that we could have to do is if we have this, if the principal does revoke the agent's authority, let's say I now revoke it from you, I am going to need to notify the agent of this. And also the third party should also be notified of that revocation. Because that I don't want what? Third parties may be still working on behalf with the agent if I revoked whose authority? The agent's. Do you see where we're going? So not only do I have to notify the agent that I'm revoking their authority, but I also would maybe want to let that third party know that, hey, they no longer are acting as an agent on my behalf. Termination by operation of law. This occurs when either party dies, even if the other party doesn't know of the death. So, and what are some of the other ways when we talk about operation by law? We could have insanity of either the principal or the agent. You could have bankruptcy of either the principal or the agent. You could have impossibility of performance because let's say the subject matter is destroyed. Like if I have you selling a painting and it's a rare Michelangelo painting and the painting is destroyed in the fire, can you still sell it on my behalf? No, because the painting no longer exists. So it's going to terminate our agency relationship. The other one is if the principal's country is at war with the agent's country. And I know that sounds funny, but again, you might hire an agent in another country to do what for you? A transaction. Do you see where we're going? Because maybe they know that area and I'm over here in the U.S. and maybe they're over there in Russia or they're over there in Japan or, do you know what I mean? And then you get into that. There is the Uniform Durable Power of Attorney Act. That provides that the agency actually is not terminated upon a principal's subsequent disability or incapacity. And that's kind of talked about on page 733. The UDPAA changed common law and general rules that the principal's insanity terminated the agent's authority to act for the principal. The durable power of attorney can be granted for different areas, but the competent principal or the death of the principal can revoke a durable power of attorney. If we happen to have an agency that's coupled with an interest, the principal cannot revoke the agency before the expiration of the interest. So earlier when I was talking about you could have agents and I said, is there an interest coupled with it? If they have an interest that's coupled with it, you can't revoke it. If the principal does revoke that agency, they have to give notice of that revocation before the agency terminates. And the principal will want to inform any third persons, like I said, so that the agent cannot bind them to any future transactions. Any question on this chapter? So then let's jump over into the next chapter. And we're still going to focus on agents and stuff. And that's why I kind of like doing these together because I think it starts mapping it further. In the agency relationship, you'll have certain rights, you'll have and certain liabilities are determined by the various factors, including the nature of the agency relationship and the agent's authority. So if you recall from what we just talked about earlier, right, where we had parties to the agency relationship, who were the parties? We said you had an agent, we said you had a principal, and then we know there's a third party involved. So we're going to go back to what we were discussing at the very beginning of class. The agent, we said, is acting on behalf of the principal, who's then entering into contracts with a third party. When the agent is acting on the principal's behalf, the agent actually can be one of 3 degrees. This agent over here, take away, I know we talked about different types of agents. Now we want to talk about who's the principal. Because they're acting on behalf of the principal, the question becomes, who is that principal? What is the degree of the principal and what can they be? So our principal over here could be either disclosed, partially disclosed, or undisclosed. And this is going to make a difference because when you have this, this will determine what liability this person might have in the beginning. Because we know that this person, this agent, is acting on behalf of the principal. We know that they are entering into a contract with a third party. And we know the contract is really between who? The principal. But what happens if we don't know that this agent is working on behalf of somebody? What if this third party thinks that they're really entering into a contract with who? The agent. And that's why it depends, was that principal disclosed, undisclosed, or partially disclosed? So let's look at these type of degrees and why are they important? Because you have to know the degree of disclosure of the principal because it'll assist you in determining what is the agent's liability to the third party. Or what is it maybe, do you see where we're going? What is that liability then to the third party depending on what that principal was? And don't think that this guy's going to walk away scot-free and not do anything because even if this person's liable to a third party, they're probably going to go after who then to get reimbursed? Indemnify the principal. Do you see where we're going? Somebody's going after somebody. It's just a matter of, are you cutting out the middleman and going directly against this guy? Or are you going against this guy? Now this guy has to get indemnified from this guy. There. So let's talk about the different degrees. Disclosed. This is where the agent has identified that they are working on a principal to the third party, and they've informed the third party that they're working on that principal's behalf. You know who the third party, or the principal is. You know who they're working for. Partially disclosed is the agent is telling the third party they're working on behalf of the principal, but they do not what? Identify who the principal is. You just know they're working on somebody's behalf, which is funny because I flicked on TV yesterday and there was one of the murder mysteries on, and it was, I can't even think of what it was. It was Lifetime. I fell asleep the night before and Lifetime channel was on, so when I woke up, it was one of the Lifetime murder mysteries, and it was about a cookbook. And it was funny because the attorney was working for a client who was undisclosed, right? Well, actually partially, because he had the guy, he said, hey, I want you to go look at a cookbook for me, the chef's book. I have a client who wants to purchase it at an auction. But he does not know who the client is. Do you get where we're going? So he knew the attorney was being an agent on behalf of what? A third party. He just didn't know who that principal was. So the attorney was the agent working on here. That principal was a partially disclosed as he was doing that. And undisclosed is the agent hasn't informed the third party he's acting on behalf of a principal. So really, that agent thinks they're really working with who? The person they're entering into the contract with, because it's an undisclosed principal. They have no idea they're working on behalf of anybody. They just assume that their contract is between these two. Now, if we have a disclosed principal situation, this is where the third party, we said, knows that the agent is acting for a principal. What we have to look at is, were they acting with authority or without authority now? Because that's going to make a difference here. If they are acting with authority for the principal, and you know who the principal is, then the principal is going to be fully liable for all the contracts that the agent entered into with that authority. Because we already know who you're acting in. So if we have disclosed, if you're going to do a chart, if you say like disclosed principal, authorized agent, right? And when I say authorized, do authority, like they have authority, then who's liable? P. Do you see where it's going? If the agent, because we said that contract's between the principal and the third party, but what if the agent is acting without authority? Then who do you think is going to be liable? So if you have a disclosed principal, but now the agent's without authority, and right now there's no ratification or anything, the agent. Do you see where it goes? So here, because they've actually breached their implied warranty to the third party, the contract is not going to bind who? The principal. But the agent could be liable. Do you see where we're going? So I'm going to just kind of say A could be liable. But principal's not bound. Right here, because we said he has not ratified it. If we have a partially disclosed principal situation, we said the third party is aware that that agent is acting for a principal, but he's not aware of who the principal's identity is. Because the third party doesn't know who the principal's identity is, the contract then is going to be deemed made with who? The agent, and the agent would be liable. Which means if it's partially disclosed, okay, we go after the agent is liable. And once that agent is liable, the agent will turn around and get his, what? Stuff from that partially disclosed principal. If you have an undisclosed principal situation, because the third party is unaware that your agent is acting for any principal, who's going to be liable? Same thing. The A will be liable. The agent will be liable there. Okay? And both the partially disclosed and the undisclosed, if the agent were acting with authority, the principal will also be liable on the contract. Assume the third party chose to sue the agent and the agent is found to be liable, the agent's going to turn around and go after who? The principal. If they're acting without authority, that's where you have to figure out then, did they ratify it or not? Because if they're acting without authority, who do you think is going to be bound? The agent is the one who could be liable. Okay. And by the way, they won't get any reimbursement then from the principal because they acted without authority and he did not ratify it. And that's what I'm kind of looking at. That's why I wanted to stress they didn't ratify it. Okay. Now, when the agent acts with authority in both the disclosed or undisclosed principal situation, the agent's statements will bind the principal. Likewise, a payment made to an agent with authority to accept the payment is going to be a payment to the principal. We discussed all these different degrees for the principal's disclosure, but here's a question for thought. What do you think are some reasons why the principal may wish to keep his identity a secret in a transaction? Why do you think they'd want to keep it a secret and maybe be known as this? Go, Brad.
Because, like, if I'm buying from somebody and I know that they don't like me, I'm like, why would I want to tell them so that they can be like, it's like $1,000 more. Congrats.
That could be one reason, because you know they might not sell it to you had they known. Yeah. Huh? But if it's illegal, you're not going to be able to do so.
Oh, okay.
We're still going to treat contracts, because don't forget, contracts is still going to apply here, because it's agency relationship of who's liable in the realm of things. But why would you not want to why would you want to kind of keep yourself undisclosed? It kind of goes down to some of it what Brad said. If you know the party might not sell to you, not that you're defrauding, by the way. We're not going to do anything illegal defraud, because if they never ask, are you working for somebody? Do I have a duty to disclose I'm working for someone? No. So if they sell that person the painting and then I turn around and get the painting for that much, and they find out later I didn't do anything wrong, as long as that agent didn't commit fraud or anything, we're okay. But now if they ask, are you working on behalf of somebody? And I say what? No. But I know I'm really working on that person's behalf, then we might have some issues. Another thing too is, once the principal's identity is disclosed, they're also going to automatically be what? Bound, liable. So maybe they don't want that liability right off you know what I mean? There. Let's talk about Tom. Tom owns a Picasso painting which Jerry knows will never be sold to him, as Jerry and Tom are enemies. Yeah, I'm talking about Tom the cat and Jerry the mouse, right? So Tom wants this thing. He knows Jerry will never sell it to him. Where have I been putting? Yeah. Here's my agent. My third party's down here. I'll do that. Okay. You'll see why in a minute. He's the principal. Okay. So what happens? Jerry is aware. Oh, I did it backwards. I was doing it the right way. Jerry is aware that Tom is in some financial difficulties. He may have to liquidate some assets. So what does Jerry do? Jerry goes, wrong party, sorry. Jerry goes and he hires, I call him Alan because I can never remember what that dog's name is. So we'll call him Alan the agent. Jerry hires him because he wants the painting from Tom, because Tom's in financial difficulties. He knows Tom does not like him. Tom will never sell him the painting outright, so he hires Alan to go and get the painting. But he wants to remain an undisclosed principal. He does not want Tom to know that he is purchasing it. So what does Alan do? Alan goes and he purchases the painting from Tom with money that was supplied by Jerry. Subsequently, Tom now, after he sold the painting to Alan, and then Alan eventually gave it to who? Jerry. Tom now learns that who has the painting? Jerry. And what does he do? He says, I have the right to rescind this contract because of your fraud. Who wins?
Jerry.
And why?
Didn't do anything wrong.
Right. And that's where I'm saying, like here, you're undisclosed. You might not want it, which goes back to when Brad said, well, maybe because I know someone won't sell it to me, right? I'll get the undisclosed. And that's what he did here. Now, again, if I said the same facts, if I said, had Tom said to him, are you working for somebody? And he says, yeah, but I'm not entitled to disclose it, right? And now let's go even a step further. And Tom says, well, if it's Jerry, I'm not selling it to you. Oh, no, it's not Jerry. Don't worry. Do you see where we're going? If he's even asked him, is it Jerry you're working for, and he lies, then we might be able to rescind it.
Could the principal sue the agent if he wanted to be undisclosed and he disclosed him anyways?
Well, he might for his negligence. Do you know what I mean? If it, like, say, if he doesn't get what he wanted, maybe if he lost out, he might claim that you breached or you're negligent. You know what I mean? You breached your agency. Yeah. Any other questions on that so far? Let's do another one. We have Paul Bunyan. Paul Bunyan is the owner of Blue Ox Wood Products, Inc. It does business as Blue Ox Marketing. Bunyan purchases merchandise from Tree Emporium from April 24th to June 24th using the designation Paul Bunyan Blue Ox Marketing on orders and correspondence. In October, Tree Emporium was notified that Bunyan was acting on behalf of the corporation when the merchandise was purchased. Tree Emporium sued Bunyan for payment for the merchandise. Bunyan contends that he was an agent of the corporation and thus not personally liable. So I will repeat this. Paul Bunyan, he's the owner of Blue Ox Wood Products, and he does business as Blue Ox Marketing. Bunyan purchases merchandise from Tree Emporium from April to June using the designation Paul Bunyan Blue Ox Marketing on orders and correspondence. And in October, Tree Emporium is notified that Bunyan was acting on behalf of the corporation when the merchandise was purchased. Tree Emporium had sued Bunyan for payment for that merchandise. Bunyan contends that he's an agent of the corporation and he's thus not personally liable. Who do you think wins there? Why do you say Paul?
I don't know, I just feel like Paul would win because he's not personally liable, but he is the owner of that.
Well,
I'm confused.
let me read here. Paul Bunyan, what I say his company is known as Blue Ox Woods. Okay. So that's the company. It also does business as Blue Ox Marketing. So that's the company name. It does business as Blue Ox Marketing. From April to June, it purchases stuff and he uses Blue Ox Marketing. So they think they're doing business with who? The Blue Ox Marketing, right? In October, they're notified by him that he says, oh, I'm really doing business for them, not them.
I feel like the TE, I can't remember what.
Tree Emporium.
Yeah, Tree Emporium's would win because he thought he was doing business for marketing, not for the Blue Ox Wood.
I feel,
But at the same time, he didn't exactly ask, like he did not ask Paul Bunyan, like, who are we doing business for? Exactly.
So what do you guys think?
I feel like it would be Paul Bunyan's like responsibility to disclose the fact that he was doing business as someone else, or like as a different corporation name, because you can sign as a different like as a different surname perhaps, but you know, him not disclosing that to Tree Emporium would make that a little fishy in my mind.
But wouldn't that count as an undisclosed principal? And he didn't ask him. So I feel like Paul. Because I think that counts as an undisclosed principal. And he didn't ask him where he was doing business with.
What do you think, Brad?
Would it be partially disclosed because they're technically like saying they're Blue Ox Manufacturing, but they do business? Is it like known that they do business as the marketing?
I think so. I don't know. I don't have like all those
'Cause
details.
If they know that it's the same company, then
Here's the company, but he also does business as this. And when he did the purchasing things, he marked this. So for April through June, every time he purchased, it showed this. But in October, he says, oh, by the way, I'm acting as, because then they sent the payment stuff. And they said, oh, we're not paying because I'm acting as an agent of this. It really shouldn't be this because he does business as this, but this is the company he works.
Okay.
He's the owner of that company. So he's the owner of this company, but he does business as this.
Okay.
So how many think Tree Emporium win? Prevail and get their money. How many think Paul will not have to pay?
I'm kind of like I'm kind of confused because I don't know. Because if Tree Emporium thought he was doing business for Blue X Marketing, and you said that was showing on the
Yeah,
the card.
it's Paul Bunyan is the owner of Blue X Wood Products, which did business as Blue X Marketing. He purchased merchandise from Tree Emporium using the designation Paul Bunyan Blue Ox Marketing on the orders and correspondence. But then he tried to say, I'm only an agent.
I feel like now the language of that contract favors favors for Tree Emporium because it says in all correspondence and billing. So I feel like for him to say that, I'm going by this surname, when every other bill and correspondence is based on his marketing company, I
Right?
feel like he should have gone forward and said, like, these are the two companies that I'm either the owner of or making purchases for. I feel like that's his fault, not disclosing that information, and the language of the correspondence and the emails and the billing and whatever would specify Blue Ox Marketing. So in Paul Bunyan's case, it really sucks to suck. Because if you don't disclose that, you suck.
So you still say Tree Emporium wins.
Yeah.
And here Tree Emporium will prevail, just so you guys are aware. It will be judgment for them. The contracts were made between April and June. Bunyan didn't inform Tree Emporium until October that he was actually an agent acting on behalf of Blue Ox Wood Products, Inc. Because he didn't make it known that he was acting as an agent for the corporation at the time the contracts were made, they're going to hold him liable. And that's where it kind of gets into, when you said, is it partially disclosed or even undisclosed? What do we say the rule is? A is liable. The agent is liable. And he says, I'm acting as an agent. That type of thing there. And eventually it will probably go, if they then say ratify or say, is the company there, the company will take it all there. Beverly Bauman. She accompanied her mother to Memorial Hospital, where her mother was placed in intensive care for heart problems. A nurse asked Bauman to sign various documents, including one that authorized the hospital to release medical information and to receive the mother's insurance benefits directly. This form stated, I understand I am financially responsible to the hospital for charges not covered by this authorization. Bauman's mother died during the course of her hospitalization. The hospital later sued Bauman to recover $19,013.42 in unpaid hospital charges based on the form she signed, which the hospital called a guarantee of payment. Bauman contended that she signed the document as an agent for her mother and was thus not personally liable. And the question becomes, who wins? The hospital or Bowman?
Moment because it wasn't disclosed principal. Yeah.
You got it? She got it. She's there. It is for Bowman. She acted as an agent for a disclosed principal, her mother, unless the contract clearly states otherwise. The agent doesn't have any personal liability on a contract for a disclosed what? Principal. I'm signing on behalf of my who? My mother. She'll be liable for this medical. I'm not personally what? Guarantee her medical payments. She's disclosed. I'm just signing on her behalf.
And because of the fact that the principal died, does that make the contract therefore avoidable? or terminated.
The agent will no longer have authority
Yeah,
to terminate there. And then what'll happen is they'll just deal it out with the estate.
Oh,
Do you get where we're going? Like if she died, like do you owe anything? It'll come out of the estate where they put in claims and stuff. But they may not take, hypothetically, because we get into wills and stuff later in the course. Do you get what I mean? There's a pecking order on who takes what. So when you die, people have to put in claims if you owe money and stuff, and then it goes by like what gets paid first and if there's any money left over after we paid all these things. You might have something left in your thing to give to family, you might not have anything. So yeah, it's kind of like bankruptcy. Remember how bankruptcy does the same thing? When the agent enters into a contract, the contract should state the principal's name and identity, capacity. So what you're going to want to do is you're going to want to put things like for, by, so they know. So what I'm going to do is we're going to draw some stuff on the board of how you might want to sign. Because if I sign certain things and I just sign my name to the contract, it might look like that I'm not acting as someone's agent. I'm also as part of what? The contract. So this is why I said you want to designate things out. So let's look at some of the ways the agent can sign and who could be liable in those situations. And by the way, courts do allow for parole evidence rule to come in. And if you guys recall from B-Law 1, parole evidence was if there's any ambiguity in contracts, remember fraud, duress, mistake. We do not let anything come into the contract that if it's a fully integrated contract, unless it's coming in to show fraud, mistake, duress, all that stuff. So we'll allow, if that is involved, to come in here. So let's look at some of these ways. This is going to be our signature side. This will be who's responsible. Okay. So what if I happen to sign it? P Company, Art Smith, agent. So Art Smith is the agent, and he signs the document P Company, Art Smith, agent. Who's going to be responsible on this contract? Who?
P Company.
P Company. I'm just going to abbreviate there. Because they're acting as what? An agent, and they're disclosing who they're acting on behalf of. What if he signed it? Art Smith, agent for P, and I'm just going to abbreviate company.
Still P Company.
It's still P Company. Okay? What if we do this? Art Smith on behalf of P Company. Everybody's in agreement, right? Nobody's disagreeing yet? Okay. What about P Company? And I'm just going to abbreviate those. Per Art Smith. Who's liable there? What'd you guys say? It is still P Company. How about P Company, comma, Art Smith?
Yeah, would it still be P Company? Because
She says still P Company. What do you guys
but
think?
he didn't put that he was an agent for P Company, so I think Art Smith would be.
yeah, there's no language of agency.
So who could be liable? And
Oh, both.
both. Because it looks like what?
That they're both doing the contract.
Correct. Do you get where we're going? Because it doesn't say he's working on behalf of, so it could be what? Oh, the company is liable as well as you? What if he just signs it like this?
Then Art Smith, because it looks like he's the one doing the business.
Yeah.
On behalf of-
Correct. How about this one? P Company, and I'm going to abbreviate company just so you guys know, by Art Smith.
I think P Company's liable.
Yeah. And here, they'll tell you this one is probably the preferred method if you're going to do it. Do you know what I mean? Instead of saying, you can say by Art Smith, but you'd probably be better off doing something like that. Do you know what I mean? But there. What if it's just signed P Company? Yep. And what if we had P Company by Art Smith agent? So you can see when you sign, the ones that you get into trouble with are what? These two. Because it doesn't look like you're signing as what? An agent. And here, you wouldn't even know you were working for a company because you don't even mention the company. You know, and that's what they're saying. You want to kind of designate that you are working as an agent because that'll help relieve your liability. Now, the principal can be liable for the agent's torts or crimes in certain situations. Okay, depending on the nature of the agency relationship, the nature of the act, and whether the act is committed within the scope of employment is going to determine the principal's liability. So when we talk about the agent's negligent act, it will result in the principal's liability under what is known as the doctrine of respondeat superior. I kind of mentioned that earlier in the class because this is where we will make you vicariously liable. Respondeat superior is that action that makes you vicariously liable for somebody's act. So if you were the employee and I'm acting within my scope of employment, and let's just say I'm hauling the hay and I'm throwing it back and you happen to be walking behind and I'm not paying attention and I what? Throw her back, knock her off, she falls over, breaks a couple bones because you know she gets knocked in the process, maybe falls down a few steps, and now she sues the company for because of what I did while I was in the scope of employment, my negligence, they could be vicariously liable for my actions. So we get into those type of things there. They could also be liable for the agent's intentional torts if the intentional act advanced the principal's interest. Okay, constituted fraud or was the result of the principal's negligence in hiring or retaining of employees. And an agent's crimes at the principal's directions can also result in criminal liability for the principal. So I have a few examples, and I'm going to pass this before I forget. Okay. So let's go through our examples. I have slug hitter. Slug hitter is a little league baseball player who seriously injured at a practice session when he was struck on the head by a poorly thrown baseball from a team member. I'm a clumsy. The league was organized by American Legion Post 54. Todd Smart and Bill Helpful were the volunteer coaches of the practice session. The hitters sued on behalf of Slug against Post 54, claiming that the coaching was negligent and that Post 54 was vicariously liable for the harm caused by the negligence. Post 54 contended that it had no right to control the work of the volunteer coaches or the manner in which practices were conducted, and as a result should not be held vicariously liable for the actions of the coaches. Who wins? Who's right?
I hope that batter doesn't win. Yes.
And why?
Because it's just, that's how you practice. Like, you kind of know what's going on.
Yeah, like-
It's just a pitch. It's not they didn't mean to hit the person. It was just a pitch. You're in the batter's
It's like
box.
when you go to a baseball game and they, like, on the Jumbotron, they say, we're not liable for any foul balls or bats that...
Well, that gets into the negligence area assumption of risk. Which,
Well, yeah, that's what I'm saying.
if
You
he's
should assume
suing
the
the
risk.
coaches, I would definitely argue that argument to say you assume the risk of the hit. The question is Post 54 liable for the coaches? Were they an agent or not? You see where we're going?
So who was supposed to be born?
I will reread it.
Okay.
I will. Slug hitter, a Little League baseball player, is seriously injured at a practice session when he was struck on the head by a poorly thrown baseball from a team member, I'm a clumsy. The league was organized by American Legion Post 54. Todd Smart and Bill Helpful were the volunteer coaches of the practice session. The hitter sued on behalf of Slug against Post 54, claiming that the coaching was negligent and that Post 54 was vicariously liable for the harm caused by the negligence. Post 54 contended it had no right to control the work of the volunteer coaches or the manner in which the practices were conducted, and as a result should not be held vicariously liable for the action of the coaches.
They're volunteers, so they're not getting compensation, right?
Right.
So,
Right. Were they an employee agent and stuff? No, they're volunteers, so judgment was for Post 54. So don't worry, he didn't win either way. And that's why I'm saying if he sued the coaches even, I would claim assumption of risk. You know, you could be injured by a ball being thrown, you know what I mean? Because that would have been your,
Shouldn't it be in your contract too? So
well, that's why it'd be an assumption of risk, that you're doing an activity that you know there's inherent harm could have result. You're
It's like-
assuming the risk.
It's like when you go to a baseball game and say, hey, these guys do this for a living. There might be a foul ball at you that enter the stands. If you're dumb, guess what? You're dumb.
And it gets there. Let me do another, I have,
It-
2, 3 more. Beauty. Beauty is a guest at Beast Hotel. Whilst, Beauty, so she's a guest at Beast Hotel. She's sitting in the lobby when Lumiere, a hotel employee, drops a heavy vacuum cleaner on her knee. When Beauty complains, the employee insults her and hits her with his fist, knocking her unconscious. She sued the hotel for damages. Is the hotel liable?
Yeah.
Why?
Employee.
He's the employee, by the way, not she.
Yeah. he's
Yeah.
employee, yeah.
So you guys say yes because he's an employee and he's gonna be
Yeah.
vicariously liable?
He's acting on behalf of the
What
company.
were you gonna say?
I was gonna
Because you
say,
started one way and flipped.
I was gonna say no because they're an employee, they're not an agent of the hotel, so I feel like, the person who dropped the vacuum cleaner would be liable, to have to pay for the damages and stuff.
Well, and this is where we wanna know, is the hotel gonna be vicariously liable? Respond as superior. Here's the question. Was Lumiere acting within the scope of employment when he hit her?
With the vacuum or with?
Yeah.
his
No, when he
fist?
hit her.
Oh.
Oh, no.
Now,
That-
if
that's-
she would have sued just for the damages of the vacuum, was that within the scope of employment?
Yeah.
Could they have been liable maybe for that?
Yeah, they
Yes.
would be liable for
But for the
that.
hit, they're not vicariously liable for the employee's acts that are outside the scope of employment. The assault was a sudden, inexplicable act without apparent purpose and completely outside the duties and scope of his employment, and is not chargeable to the hotel of the doctrine of respect. And that's why we said, you have to then hear with their employee, is it within the scope of employment? You know, same with the agent, is it within that scope? Remember, because we said it doesn't apply to certain categories, but it does there. I could do this one. Harry Henderson, he's an employee of Blow Me Down Flying Service. He stole a General Electric Credit Corp aircraft. He crashed the plane while attempting to take off. General Electric sued Blow Me Down on the theory that it had negligently hired Henderson as an employee and was therefore legally responsible for his act of theft. Henderson had a military prison record as a result of a drug offense and had been fired by Blow Me Down twice previously, but had been immediately reinstated each time. Blow Me Down claimed that the evidence was insufficient to establish that it had been negligent in employee Henderson. What do you guys think here?
Can you read it, please?
And by the way, I changed names, but all these problems came out of your textbook questions, just so you guys know. Harry Henderson, an employee of Blow Me Down Flying Service, stole a General Electric Credit Corp aircraft and crashed the plane while attempting to take off. General Electric sued Blow Me Down on the theory that it had negligently hired Henderson as an employee and was therefore legally responsible for his act of theft. Henderson had a military prison record as a result of a drug offense and had been fired by Blow Me Down twice previously, but had been immediately reinstated each time. Blow Me Down claimed that the evidence was insufficient to establish that it had been negligent in employee Henderson. What result?
Blow me down, it's not win,
And why do you say that?
because they're saying they didn't know about the military things or whatever. And they fired him 2 times, so that would be negligence on their behalf because they hired him knowing, well, not knowing all the stuff that happened.
And here it is, they say Henderson had a negative employment history and Blow Me Down had sufficient notice that he could create problems for it. The failure on the employer's part to take action when an employee is dangerous is negligence. Now, there's a big paren, I'm gonna tell you, because this case had a lot more involved, because this was based on a real case in your textbook. It's in the back problems. Please note, Blow Me Down faces an interesting dilemma with respect to Henderson's right under the ADA and the liability for his conduct. If Henderson has a substance abuse problem, it could be classified as a disability so long as he is able to perform his job with reasonable accommodation. Blow Me Down would be engaging in discrimination if it fired Henderson. So they could have been negligent in their hiring, but you get where they're going to flip? If they outright now fire him because of this and he really has a disability, they could be subject to a discrimination lawsuit from him besides the other lawsuit from the other person. The EOC has stated that the facts an employee might snap and that substance abuse recovery is often tentative are not reasons for termination of the employee with disabilities, thus potential exposure for negligence liability isn't a valid reason for discrimination.
Wouldn't the employer in some cases also be liable to provide like counseling or therapy?
Well, that's why they're saying like,
Or-
they might be liable for his negligence action to this other party, but they gotta be careful because if they now fire him, they could be subjecting themselves to discrimination because he might have a disability and they might have to accommodate his disability.
So would their best course of action to like be providing those services, and then if those services don't work, they have a cause of termination?
As long as they're not in violation of law
Yeah, like as long as they provide those services
and it's reasonable
to him,
accommodation.
yeah, reasonable,
Yeah.
and he's still, yeah.
The last two things I want to talk about, principal though is generally not liable for independent contractors acts, because we were talking about employees right now and those type of things, if there isn't a great degree of control over the independent contractor. However, if the independent contractor is engaged in inherently dangerous activity, let's say you hire them to blow up a building for you. Do you get where we're going? Even though you're not their employer, and you hired an independent contractor to do that, you still could be liable. That's gonna be the exception to that rule, that you're not liable for independent contractors. Do you get where we're going? So the exception, because they'll say it's a dangerous activity, you're liable because of public policy interest here and holding those parties accountable for the hazardous activities rather than insulating yourselves from not being liable. You know, and then the last thing is you need to be aware of is a salesperson is a soliciting agent who doesn't have authority to make a contract with that will bind the principal. The soliciting agent's authority is limited to soliciting offers from a third party and transmitting those offers to the principal for acceptance or rejection. And then the book also mentions the contracting agent, and that contracting agent does have authority to make contracts with third parties that will bind the principal. So the last 2 points in the book. Any questions on the material? If there are no questions, I'm done. Like I said, I have a couple more exams out. You guys are free to look at yours, but I'm going to keep them. But I will give them back, I promise, once everybody takes the exams. So, and I know you guys all know at least what you score, where you stand in the class.
Good luck with today's lesson.